Yeah, I'm going to be showing you another person's videos today. Get over it. Sup, Wolverines, and welcome back to the channel. I'm not going to do a lot of talking right now because I'm going to be showing you a video from Armed Attorneys. Armed Attorneys is an awesome YouTube channel ran by two people, and they happen to be GeoWave's legislation team in Texas. So give them a follow down below and let them know that I sent you. And with that, let's go ahead and roll their video.
Right answer or the answer you want to hear?
We are the Armed Attorneys. Today we're giving a critical update on the force reset triggers. You won't want to miss this stuff. We're answering a lot of questions about what to do if the ATF shows up your house with a search warrant. What if they don't have a search warrant? Do you consent to searching? Do you even open your safe for the ATF? What to do if you maybe find yourself in one of these positions of being in possession of an FRT. But before we begin, show your support for the Second Amendment by hitting that like button. And to start things off, Emily, when we're talking about force reset triggers, what are we talking about?
FRTs, I mean, first of all, they're not auto sears,
Nope.
right? But what we've got, and, gunsmiths, please excuse me, because I'm going to use a very Emily's layman, description here, but the mechanism of the trigger is forcing itself forward such that, essentially you're firing faster than you would have with a factory trigger. However, we still have one pull of the trigger, one bullet discharged from the barrel, right? I mean, there is no multiple bullets discharged from the barrel based on one trigger pull. It just is happening faster and swifter than it would with a factory trigger.
Yeah, and what the issue is, but at the time that these items were purchased, these came out of rare breed, and at the time that these were purchased, they weren't being given a lot of scrutiny from the ATF. Nobody considered these things machine guns because mechanically they weren't. Just
because they're not.
Yeah, because they're not.
Spoiler alert for the tone of the video here.
Yeah, but no fault of the average gun owner, person purchasing these directly from the manufacturer, purchasing these from a gun store or at a gun show. But the ATF has changed the way that they look at these things and are no longer considering them just a trigger group. Now they are considering them machine guns. And how do we get there, Emily?
Well, illegally.
Yeah.
But no. So here's what we do. We have our definition of machine gun. And then, of course, you can see previous videos where we talk about how the ATF makes rules and why they get to do things like this, perhaps for a limited amount of time now going forward, but why they historically have been able to take the laws promulgated by Congress and figure out how they want it to be interpreted. So we have a definition in the United States Code of machine gun. And I am going to give it to you in its entirety here because it's important. The term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall include the frame or receiver of any such weapon, any part designed and intended solely and exclusively or combination of parts designed and intended for use in converting a weapon into a machine gun. So that's our auto sear. Pause in the definition.
Right.
Back to the definition. And any combination of parts from which a machine gun can be assembled if such parts are in the possession or under the control of a person. So this is why you can be in possession of nothing but an auto sear. You can wear it like a necklace around your neck. And as far as the federal government is concerned, that is the machine gun. That is the hot lava. You are in big old trouble.
Yes.
Technical legal term.
And so we got a letter. The ATF released a letter back in March of 2022 explaining, hey, we are considering these things machine guns. We are reinterpreting this law to say that these are machine guns.
Right. And bear in mind, the definition did not change.
Right.
The law has not changed. In fact, the ATF hasn't even put forth a new rule.
Yeah, that is an interesting thing to point out because unlike, we saw the bump stock rule where they took the definition of machine gun in the Code of Federal Regulation and they amended that. And it doesn't, I'll tell you, it doesn't match the definition that Emily just read. We see that from time to time that the agency will go and attempt to redefine things, and they're not even doing that. They're reinterpreting things. And so that's very difficult for us average law-abiding gun owners to be mind readers of the random ATF bureaucrats who decide that they wake up, their head pops off the pillow in the morning and say, I'm going to redefine how this definition should be interpreted. So
I like to see that. A good mental picture.
Yeah, but we got this letter back in March of 2022, and essentially they said, hey, we're going after the sellers and possessors of these FRTs. We're treating these things as machine guns. There's some additional language in this letter. It's very long. But, I will say they have one line in here saying, if you have any questions about how to dispossess yourself of one of these FRTs, contact your local field office. And that's where I hear the record skip off. It's, in my brain. And what do you tell folks about contacting law enforcement?
This is something people are calling us about. I mean, I would say in the last 2 days, I've spoken to at least a person per day because we've had tons of calls over the last several weeks on this issue. You get that letter from the ATF and you think, I didn't think I was doing anything wrong. It was legal when I bought it. They know I have it. They're asking me to hand it back to them. I am telling them no.
Yes. Again, the crime here is possession. If they find you in possession of this thing, there is a high likelihood extreme risk of getting charged with a very serious federal felony. Now,
don't keep it.
Yeah,
right.
Don't keep it. And
don't stop watching after we said that and
yes.
keep it.
No, and so I think it'd be best. We'll get to kind of our guidance and things that we've been telling our clients, but let's talk about a couple of different scenarios. The ATF shows up at your house with a search warrant. What do you do in that scenario, Emily?
Well, you can ask to see the warrant. You are not going to stop the warrant.
Right.
I think we've seen evidence of that fairly recently. Federal government's got a warrant. They're going to do what they're going to do. The time to challenge that is later. Now, the question arises, what do I do if they want me to open up my safe in the execution of this warrant? And Richard, you've got good things to tell people on that.
Yeah. So here's the deal. With regard to opening up your safe, if they have a search warrant that says they can get into the safe, they're going to get into the safe. Okay, whether you open it or not. But here's kind of the rub. Let's say they say, hey, open up the safe for us. If you were to open that safe for them and later the warrant is invalidated, a court would likely interpret you opening that safe as consent. So in order to preserve all of your rights, the best practice would be to not open the safe. Now, don't get me wrong. They're completely going to destroy your safe. Are you going to get reimbursed for that?
No, absolutely not. They do not have to reimburse you, and they will not reimburse you for destroying that safe.
But to preserve your rights, the answer is you shouldn't voluntarily open the safe. And that comes to one of our biggest exceptions to the warrant requirement, which is consent. And so that brings up the scenario. What if they come to my house? They don't have a search warrant.
Do not consent.
Yeah.
Do not consent. Do not let them in. You do not have to. And get an attorney on the phone immediately. You might say to yourself, I already dispossessed myself of my FRT. I've got nothing to hide. I'll let them in and search. Do not do it. It is never a good idea. You just never know.
Right.
And also, do you trust this ATF?
And I'll tell you, the harassment by the ATF, this ATF is up a lot. I was talking to another colleague about this, and I want to say we're seeing 5 or 6 times what I saw a year ago as far as harassment of regular, ordinary people, of FFLs. And so this ATF seems to be out to get folks. So, but that brings up another scenario. What happens if you get arrested? Well, at that point, you need to invoke your right to remain silent. You actually have to say out loud, I invoke my right to remain silent. Invoke your right to an attorney. Say it out loud. I invoke my right to an attorney. And do not speak to the ATF without an attorney present. Now, getting to that question that's burning in the minds of people now. What if they happen, and what have you been telling your clients? And again, this is not legal advice. You got to consult your attorney about your particular circumstances. But what have you been telling your clients, Emily?
Yeah, and so this is where people are just getting letters. Or maybe you haven't gotten a letter. Maybe you just know, I've purchased one of these. I know there's something happening. What do I do? Everything is individualized based on your circumstance. But my primary advice to my clients has been, you should dispossess yourself of that FRT, likely by destruction. That is the best way. And I know that really there are people already typing angry comments because I'm telling you to destroy it. And yes, I do believe they are violating our Second Amendment rights. However, I also don't want to see you in federal prison. And so we've got to weigh the legal fight that is going to happen to help preserve our rights in this issue versus, do you want to be sitting in prison while that fight happens? As a criminal defense attorney, my answer to that has to be, no, I do not want my clients sitting in prison, which is why I will advise dispossession by destruction. And if you're one of those types who's a little bit finicky, which many people are, You may choose to snap a photo of the destroyed item. Do not send that to anyone. Do not give that to law enforcement. That is something that you could share with your attorney later on if you are in a pinch, and the attorney will decide whether or not to share that with the government.
Yeah, and here's why, we see a lot of folks, and I see this on internet forums, hey, destroy it, take a picture when the ATF shows up your door, give them the photograph. Well, here's the problem with that. Just like the March 22 letter saying, call us and ask us how to get rid of it. I mean, essentially, you are tattling on yourself. You are confessing to a crime. You are showing them, hey, I possessed this item. We don't necessarily want you to be serving up on a silver platter that you committed a federal felony. And so that's why it's important. If you do snap a picture of it, the way that gets communicated to law enforcement or the ATF, it's through your attorney. What your attorney says can't be necessarily used against you. They can decide whether or not to disclose something, how something is disclosed. And so that's one of those deals where you really need your attorney to be a gatekeeper in that scenario.
But I've definitely been telling people, let's say you received the letter, do not respond to it.
Right.
Do not contact the ATF. Do not contact law enforcement. Do dispossess yourself. Again, I'm sorry. I know it's $500 lost. It's rights lost. That fight happens later. It's already happening. But do not affirmatively reach out to law enforcement. Just keep yourself safe. Remember that law enforcement ask people to reach out to them regularly, and it doesn't work out well, and people who are kind of dumb enough to do it get in a lot of trouble. Like every once in a while they'll say, hey, come bring in your opioids, we're going to test them to make sure there isn't a bunch of fentanyl in them, it'll kill you. Guess what happens when you bring your opioids to law enforcement? They're not testing them. Right. They're arresting you.
Yeah, and we get it. It is a frustrating situation. The stuff wasn't a crime. They changed their mind. Inherently, it feels wrong. There's litigation pending, and we hope and we believe that they will be victorious on the other end of this, because it is such a significant infringement on the Second Amendment. However, the penalties are severe, up to 10 years in prison, up to a $250,000 fine. And that's where we say, hey, do I want to be this test case? Some folks say, you know what? $500 is worth me becoming the test case in this scenario. And that's where you speak to your attorney, you make your decision about that kind of stuff. But every person's circumstances is different. And that's why it's so important that you speak to your attorney about your particular circumstances. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please continue to question and comment below. Until next time, we're the Armed Attorneys.
That was pretty good advice. And I just want to thank the Armed Attorneys for their information and for letting me share this video, because I think it's important for everyone to watch what they said. All right, guys, that is it. Stay vigilant, stay free, keeping the fight. I am out of here. Wolverines, motherfucker.